Before we dive in, it's critical to understand that the information in this presentation is for educational purposes only and does not constitute legal advice. We are not attorneys. The laws surrounding arrests, searches, and your rights can be incredibly complex and vary significantly by state, county, and even the specific circumstances of your situation. This video is intended to be a general guide to empower you with knowledge, but it is never a substitute for consulting with a qualified criminal defense attorney who can advise you on your specific legal issues. Imagine this. It's late. You're driving home, minding your own business. Maybe the music is a little too loud, and then you see it. Flashing red and blue lights exploding in your rearview mirror. Your stomach drops. Your heart starts hammering against your ribs. You pull over, your hands get clammy. An officer approaches your window, flashlight beam cutting through the darkness. You can't quite make out their face. They ask for your license and registration. And then they ask you a simple question. Do you know why I pulled you over? What you say and do in the next 60 seconds could fundamentally alter the course of your entire life. That is not an exaggeration. That is a fact. And the terrifying reality is, most people have absolutely no idea what to do. They rely on what they've seen in movies. They try to talk their way out of it. They get nervous, they over-explain, they accidentally admit to something they didn't even do. And just like that, a routine traffic stop spirals into a nightmare. Suddenly you're being asked to step out of the car. You feel the cold, sharp click of handcuffs on your wrists. You're being read your rights as you're placed in the back of a police car, watching your own car, your freedom shrink in the distance. This isn't a rare Hollywood scenario. Over 10 million arrests are made in the United States every single year. That's more than 27,000 people a day. One person every 3 seconds. These aren't all hardened criminals. They are teachers, nurses, college students, construction workers, and grandparents. They are regular people who found themselves in the wrong place at the wrong time, or simply made one small mistake that cascaded into a life-changing catastrophe. So this isn't just a video. This is an insurance policy. This is a step-by-step playbook for navigating one of the most stressful, confusing, and high-stakes situations you could ever face. My goal is to strip away the fear and the uncertainty and replace it with knowledge and confidence. Because in an encounter with law enforcement, knowledge isn't just power. It's your shield. It's the only thing that stands between a minor inconvenience and a permanent mark on your record that could affect your job, your ability to get a loan, your housing, and your future. Let's be clear. The purpose of this is not to be anti-police or to teach you how to be difficult. The vast majority of officers are professionals doing an incredibly tough job. This is about being pro-you. It's about understanding the rules of a game you are forced to play the second those lights flash behind you. The police know the rules. They train on them every single day. You need to know them too. So let's go back to that moment. The lights are flashing. You've pulled over safely to the right side of the road. What is the very first thing you should do? Before the officer even gets to your window, turn on your interior dome light. Place your hands on the steering wheel at the 10 and 2 position and keep them there. This is a nonverbal signal. You are communicating that you are not a threat, that you are cooperative, and that you have no intention of reaching for anything. It immediately de-escalates the situation and sets a professional, non-confrontational tone. When the officer arrives at your window, they will ask for your license, registration, and proof of insurance. You are legally required to provide these. Don't fumble around for them. Know where they are. Have them ready. Tell the officer what you are doing before you do it. Officer, my registration is in the glove box. I'm going to reach over and get it now. My wallet with my license is in my back pocket. I'm going to get it for you. Narrate your movements. No sudden moves. Now comes the critical part. The questions. Do you know why I pulled you over? Where are you coming from? Have you had anything to drink tonight? Your brain will be screaming at you to be helpful, to explain, to be friendly. You will want to say, was I speeding, officer? Or, I only had one beer with dinner a few hours ago. You must fight this urge. This is the first and most important rule. You have the right to remain silent. So use it. Politely. Respectfully. But firmly. The magic words are not complicated. To the question, do you know why I pulled you over? The correct answer is a simple, no, officer. To any other questions about where you've been or what you've been doing, the answer is, I'd prefer not to answer any questions, officer. You can also ask, am I being detained or am I free to go? This isn't being difficult. It's being smart. Anything you say can and will be used against you. Not might be used against you. Will be used against you. You think you're explaining yourself, but what you're actually doing is giving the officer evidence. You admit to speeding, you've just confessed to a traffic violation. You admit to one beer. You've just given them the reasonable suspicion they need to ask you to step out of the car for a field sobriety test. Your words are the tools they can use to build a case against you. Don't hand them the toolbox. Let's say the officer decides to escalate. They say, "I need you to step out of the car." This is where many people get confused. Can you say no? In almost every jurisdiction in the country, the answer is no. For officer safety, the courts have given police the authority to order the driver and any passengers out of a vehicle during a lawful traffic stop. So if you are ordered out, you comply. You step out of the car, but you do so slowly and you keep your hands visible. Now you are standing on the side of the road. The situation has changed. You are now being detained. This is a crucial distinction. Being detained is not the same as being arrested. A detention is temporary. It's for the officer to investigate their reasonable suspicion. An arrest requires a higher standard, probable cause. While you are detained, your right to remain silent is still in full effect. The officer will likely continue to ask you questions. The answers remain the same. "I'm not going to answer any questions, officer." Or more powerfully, "Officer, I am exercising my right to remain silent. I want a lawyer." The moment you say the word lawyer, all questioning is supposed to stop. This is a constitutional bright line. It is your most powerful tool. But let's be realistic. In a tense situation on the side of the road, the officer might not stop. They might try to rephrase the question. They might try to make small talk to get you to lower your guard. Don't fall for it. Be a broken record. "Lawyer. I want a lawyer. I will not answer any questions until I have spoken to my lawyer." Let's follow this down the path. The officer is not satisfied. Based on their observations or something you accidentally said, or something they claim to have seen in your car, they decide they have probable cause. This is the moment everything changes. They will turn you around. They will place your hands behind your back. You will feel the cold steel of the handcuffs, hear that final definitive click, and you will hear the words that every single American citizen dreads. You are under arrest. What does that mean legally? It means your freedom of movement has been completely taken away. You are now in police custody. You are no longer being temporarily detained. You are being formally charged with a crime. This is the point of no return for this encounter. The officer will likely recite the Miranda Warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. People hear this on TV and it just becomes background noise. Do not let it be background noise. It is the single most important piece of information you will receive all night. They are literally telling you the rules of the game. They are telling you to be quiet. They are telling you to get a lawyer. Listen to them. From this moment forward, the only words that should come out of your mouth to any law enforcement officer are, "I am exercising my right to remain silent and I want a lawyer." Nothing else. No small talk in the back of the car. No trying to explain your side of the story at the police station. No asking what's going to happen. Your job now is to be silent. Your only job. Because the moment those handcuffs click, a new phase begins. The search. And what they are legally allowed to search, your body, your car, your personal belongings, is one of the most misunderstood and legally complex parts of any arrest. This legal complexity stems from a direct clash between two powerful forces: the government's need to ensure officer safety and preserve evidence, and your fundamental Fourth Amendment right to be free from unreasonable searches. The framers of the Constitution were deeply wary of unchecked government power, of soldiers and constables kicking down doors on a whim. That's why the Fourth Amendment generally requires a warrant, based on probable cause, for any search. But like so many things in law, there are exceptions. And the biggest, most immediate exception you will ever encounter is called a search incident to a lawful arrest. The logic, as established by the Supreme Court over decades, is twofold. First, officer safety. When someone is being taken into custody, they might have a weapon they could use to harm the officer or escape. Second, the preservation of evidence. A person might try to destroy or conceal evidence of the crime for which they're being arrested. So the courts have given police the authority to conduct a limited, warrantless search at the time of the arrest to neutralize these two specific threats. But what does limited actually mean? The landmark case that defined the physical scope of this search is Chimel versus California. The court established what's often called the wingspan rule. Police can search your person and the area within your immediate control. Think of it as an invisible circle of reach around you. If you're arrested while sitting on your couch, officers can search your pockets. They can look under the couch cushions you were on. They can check the drawer of the end table right next to you. Why? Because you could, in theory, lunge for a weapon or a piece of evidence hidden in those places. But that's where their authority ends without a warrant. They can't use your arrest in the living room as a pretext to go upstairs and search your bedroom. They can't decide to rummage through your kitchen cabinets. That area is not within your immediate control. The threat you pose is limited to your immediate surroundings, and therefore so is the search. So, on the street, this is fairly straightforward. They will search your clothing, your pockets, your wallet for weapons or contraband. They will search any bag you are carrying like a backpack or a purse. This is all considered part of your person and the area within your immediate control. But this is where things get much more complicated and where one of the most significant battlegrounds for privacy rights has been fought: your car. For years, the rule for vehicles was a mess. Police often interpreted a traffic stop arrest as a green light to search the entire passenger compartment of the car, top to bottom. But in 2009, a pivotal Supreme Court case, Arizona versus Gant, dramatically changed the rules and reined in that power. Now, police can only search the passenger compartment of your vehicle incident to your arrest under two specific circumstances. First, if you are unsecured and within reaching distance of the car at the time of the search. This goes back to the officer safety and evidence preservation logic. If you're handcuffed and standing right next to your open car door, the logic holds. But in the vast majority of arrests, you are immediately handcuffed and secured in the back of a patrol car. Once you are locked in that police vehicle, you are no longer a threat to anything inside your own car. You can't reach a weapon in the glove box. You can't grab and swallow evidence under the seat. Therefore, the justification for the search evaporates. The second circumstance is the one that causes the most confusion. Police can search your vehicle if it is reasonable to believe that evidence of the offense of arrest is in the car. This is the key phrase: offense of arrest. Let's break that down with examples. Say you're pulled over for speeding, and the officer discovers you have a warrant for unpaid parking tickets. You are arrested. What is the offense of arrest? Unpaid tickets. Is it reasonable to believe there is evidence of unpaid parking tickets hidden in your center console or under your seat? Of course not. In that scenario, under Gant, they have no right to search your car. Now change the facts. Say you're pulled over for erratic driving, and the officer sees what they believe to be a bag of illegal drugs on the passenger seat. They arrest you for drug possession. What is the offense of arrest? Drug possession. Is it reasonable to believe that more evidence of that specific crime, more drugs, paraphernalia, sales records, could be found elsewhere in the car? Absolutely. In that case, a search of the passenger compartment would likely be considered legal. This distinction is absolutely critical, and it empowers you to understand when a search is justified and when it might be a fishing expedition. But what about the most private, personal item most of us carry? The object that contains our entire digital life. Our photos, our messages, our financial records, our location history. Our cell phone. For a while, police in lower courts treated cell phones like any other container. If they could search a wallet or a cigarette pack found in your pocket, they argued they could also search your phone's digital contents. This created a terrifying privacy loophole. A wallet might contain a few photos and credit cards. A modern smartphone contains the digital equivalent of your entire home, your office, and your filing cabinet combined. Finally, in 2014, in the unanimous landmark decision of Riley versus California, the Supreme Court slammed that door shut. Chief Justice John Roberts, writing for the court, stated that modern cell phones are such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. The court recognized that searching a phone is not like searching a physical object. It is a deep and revealing intrusion into a person's private life that is not justified by the original reasons for a search incident to arrest. So what's the rule now? Police can physically take your phone from you when you're arrested. They can seize it to prevent it from being remotely wiped or destroyed. But they cannot, under any circumstances, unlock it and search its contents without a warrant. Getting into your phone requires a judge's approval, based on probable cause that it contains evidence of a crime. This was a monumental victory for privacy in the digital age. They can seize the container, but they need a warrant to look inside. Now let's return to your car for a moment. You've been arrested. You're secured in the back of the patrol car. Based on the Gantt rule, the police don't have the right to search your vehicle. So what happens to it? You can't just leave it on the side of the road. In most cases, it will be towed to an impound lot. And this is where another major warrant exception comes into play: the inventory search. Once your car is in police custody, they are allowed to conduct a warrantless search to take inventory of its contents. The stated purpose of this is not to look for evidence. It's an administrative function. They do it to protect your property from being lost or stolen, to protect the police from false claims of theft, and to check for any dangerous items inside the vehicle. The officer will go through your car, compartment by compartment, and log everything of value. A laptop in the back seat, a toolbox in the trunk, the change in the ashtray. This sounds innocent enough, but it's a legal backdoor. While the purpose of the inventory search isn't to find evidence, if they happen to find illegal items in plain view during this routine administrative procedure, like a bag of drugs in the glove box, they open to inventory its contents. That evidence can and will be used against you. It's a crucial loophole that turns a non-investigative procedure into a powerful evidence-gathering tool. So, as you sit in the back of that police car, the journey is far from over. Your property has been searched, your vehicle is being towed. You are now fully in the custody of the state, and you're on your way to a place where your rights, your identity, and your future will be processed, cataloged, and questioned in ways you can't yet imagine. You're headed to the police station. The doors of the police cruiser open into a cavernous, concrete garage. This is the sally port, a secure bay designed to ensure there is no escape. The sound of the massive steel door rolling down behind you is a sound of finality. The air changes. It's thick with the smell of disinfectant and stale coffee. You're no longer on a public street. You've crossed a threshold into the state's domain. An officer guides you out of the car. The handcuffs dig into your wrists as you're led through a heavy door and into the station itself. The transition is jarring. The controlled chaos of the outside world is replaced by the sterile, bureaucratic hum of fluorescent lights and crackling radios. You walk down a hallway, your street shoes squeaking on the linoleum floor. You feel the weight of eyes on you. Officers, administrative staff, other people in custody. You are no longer a person, you are a problem being processed. You arrive at the booking area. It's an imposing, often circular desk, usually behind thick plexiglass. This is where your new reality is formalized. The officer behind the desk, the booking sergeant, won't ask you how your day is going. They'll take the arresting officer's report and begin the slow, methodical process of turning you from a citizen into an inmate file. They'll ask for your name, date of birth, and address. This isn't a conversation. It's data entry. Then comes the first major step in stripping away your identity. Empty your pockets. Put everything on the counter. Take off your belt, your shoes, your watch, any jewelry. Every single item you own is about to be taken from you. Your wallet, containing your driver's license, your credit cards, your connection to your financial life. Your keys, the very tools that allow you access to your home, your car, your private spaces. And most importantly, your phone, your lifeline to family, friends, and the outside world. It's all placed into a large manila envelope or a clear plastic bag. An officer meticulously inventories every item on a form, which you may be asked to sign. A wallet, brown leather. $74 in cash. One set of house keys. One silver-colored watch. This isn't just for safekeeping. This is a critical legal procedure known as an inventory search. Normally, the Fourth Amendment protects you from unreasonable searches. But once you're lawfully in custody, the Supreme Court has ruled that officers can search your person and your property without a warrant as part of this booking process. The official reasons are to protect your property while you're in jail, to protect the police from false claims of theft, and to check for weapons or contraband that could be a danger inside the facility. But the effect is that every note, every receipt, every item in your wallet can now be legally examined. Next, you'll be photographed. This is the mugshot. You're stood against a wall, often with height markers on it. A harsh, unflattering flash goes off. Face the camera. Flash. Turn to your right. Flash. This image, captured at one of your lowest moments, is now part of your permanent record. It will be attached to your file, your arrest record, and in many states, it can become public information, available online for employers, landlords, and neighbors to see, regardless of whether you are ever convicted of a crime. Then come the fingerprints. You might be pressing your fingers onto a messy ink pad and rolling them onto a card, or more commonly now, placing them on a cold glass plate of a digital scanner. One by one, each finger is scanned and mapped. This isn't just for the local police file. Your prints are uploaded to state and national databases like the FBI's Integrated Automated Fingerprint Identification System, or IAFIS. They are instantly cross-referenced against millions of other prints from unsolved crimes across the country. In a matter of seconds, the system will check if you are wanted anywhere else under any other name. In some jurisdictions, for more serious arrests, they may even take a DNA sample, usually with a simple swab from the inside of your cheek. This too enters a vast database, a permanent biological record of your presence here. Now we come to one of the most misunderstood moments of any arrest, thanks to a century of television and movies: the phone call. The trope of the one phone call is a myth. There is no constitutional right to a phone call. Instead, the right comes from state laws which vary significantly. Some states mandate that you be allowed to make a certain number of calls, often 2 or 3, within a reasonable time after being booked. Other states are less specific, simply saying you have the right to contact an attorney and a family member. But here is the single most important piece of advice you could ever receive at this stage. Who you call and what you say can change the entire trajectory of your case. Your first call should not be to your spouse or a friend to panic. Your first call should be to a criminal defense lawyer. If you don't have one, your call to a family member or trusted friend should be for the sole purpose of telling them to find one for you immediately. And when you make that call, you must operate under one critical assumption: you are being listened to and the call is being recorded. With the sole exception of a legally protected call with your attorney, every word you say on a jail phone can and will be used against you. Do not discuss the case. Do not try to explain what happened. Do not proclaim your innocence or try to create an alibi. The only information you should convey is this: I have been arrested. I am at the name of police station or jail. I need you to contact a lawyer for me right now. That's it. Any emotional outburst, any stray comment, any seemingly harmless detail can be twisted by a prosecutor later in court. Saying "I messed up" or "I can't believe this happened" can be presented to a jury as a confession. The phone call is a tool for you to seek legal help, not a chance to tell your story. After the inventory, the photos, the prints, and the phone calls, the processing continues. A booking officer will likely run through a medical questionnaire. Do you have any serious medical conditions? Are you on any medication? Are you allergic to anything? Have you ever had thoughts of harming yourself? It is vital that you answer these questions honestly. The jail has a legal duty to provide you with necessary medical care, and withholding information about a heart condition or a need for insulin can have life-threatening consequences. However, this is not a therapy session. Stick to direct, factual answers about your physical and mental health needs. Don't volunteer any additional information about your life or the circumstances of your arrest. Finally, depending on the facility and the charges, you may be required to trade your clothes for a jail-issued uniform, a jumpsuit or a set of scrubs, often in a faded, dehumanizing color. This is the last vestige of your personal identity being taken away. You are now fully processed. You have a file, a mugshot, a fingerprint record, and an inmate number. The booking sergeant nods to an officer. He's ready. You are escorted down another hallway, this one leading to a series of stark, concrete and steel rooms. The holding cells. An officer unlocks a heavy door that groans in protest. He gestures for you to go inside. The cell is small, cold, and contains little more than a metal bench and a toilet. You step in. The door slams shut behind you with a deafening clang of finality. The lock clicks, and then silence. You are alone, stripped of your property, your identity, and your freedom. In the quiet of that cell, the reality of your situation begins to crash down. The adrenaline fades, replaced by a chilling uncertainty. You are now completely at the mercy of the system. You have no idea what will happen next, when you'll get out, or who you can trust. And it is in this moment of maximum vulnerability, alone in the silence, that they will often make their next move. Because soon another officer will come to that door. And he's going to want to talk. He won't be in a standard uniform. He'll be a detective, likely in a slightly too big suit or a polo shirt and slacks. He'll walk in not with aggression, but with a calm, almost sympathetic demeanor. He might be carrying 2 styrofoam cups of coffee, or a bottle of water. He'll slide one across the cold metal table to you. "Tough night, huh?" he might say, his voice low, reasonable. I'm Detective Miller. I'm not like those guys who brought you in. They're all adrenaline and procedure. I just want to sit down man to man and figure out what really happened here. Get your side of the story. This is the moment where more legal battles are lost than in any courtroom in America. This is the start of the interrogation, and you need to understand with every fiber of your being that this is not a conversation. It is a strategic, psychologically honed process designed for one purpose and one purpose only: to secure a confession. Detective Miller is not your friend. The coffee is not a peace offering. His sympathy is a weapon. He is a hunter and you are in his territory. His goal is not to uncover the objective truth. His goal is to close his case. And the fastest way to do that is for you to give him the evidence he needs straight from your own mouth. To do this, law enforcement officers across the United States are trained in a variety of powerful and frankly terrifyingly effective psychological techniques. The most famous is called the Reed technique. And while its specifics are complex, its core strategy is simple. Make the suspect feel that the consequences of confessing are less severe than the stress and pressure of the interrogation itself. It starts with rapport building. The detective will try to find common ground. He'll ask about your family, your job, the sports team on your t-shirt. He's trying to lower your defenses, to make you see him as a reasonable person you can trust. He's creating a false sense of security in an environment that is, by its very nature, hostile to your interests. Once he feels he's got you relaxed, the real game begins. And they often start with a tactic called minimization. This is where the detective downplays the legal or moral severity of the crime you're accused of. If it's a theft, he'll say, "Look, I get it. Times are tough. The company probably had it insured anyway. It's not like you're some master criminal, you just made a bad decision." If it's an assault, he'll suggest a justification. "That guy had it coming, didn't he? I looked at his record, he's a real piece of work. I probably would have done the same thing. You were just defending yourself. Maybe you just took it a little too far." They are giving you an out. They are offering you a more palatable, more socially acceptable version of the story. But here's the critical part. That out is still a confession. Admitting you took the money because times were tough is still admitting to theft. Admitting you hit him because he had it coming is still admitting to assault. You are simply confessing to a version of the crime that they have gift-wrapped for you. If minimization doesn't work, they'll pivot to its evil twin, maximization. This is pure fear. The detective's friendly demeanor will vanish. He'll lean in, his voice will get hard. He'll start to tell you about all the evidence he has against you. And this is, without a doubt, the single most important thing you need to know about a police interrogation. The police are legally allowed to lie to you. Let me repeat that, because it's a truth that has destroyed countless lives. The police can and will lie. They can tell you they have your fingerprints on the weapon even if they don't. They can tell you they have an eyewitness who identified you in a lineup, even if no such witness exists. They can tell you they have you on high-definition security camera footage, even if the camera was broken. They can tell you that your friend, your spouse, your own brother is in the next interrogation room and has already confessed and implicated you in the whole thing. They can even fake a signed confession from that person and slide it across the table. All of this is legal. The Supreme Court has repeatedly upheld the right of law enforcement to use deception during an interrogation. They are creating a fictional world in which your guilt is an established fact. A world in which all the evidence is stacked against you. A world in which you are completely and utterly trapped. They want you to feel hopeless. They want you to believe that your only option, your only path to any kind of leniency, is to confess and cooperate. This is the innocent person's nightmare. Because if you're innocent, your natural instinct is to talk, to explain, to clear up the misunderstanding. You think, if I just tell them where I was, if I just explain the context, they'll see they have the wrong person and let me go. This is a catastrophic mistake. First, you might accidentally give them information they didn't have. Maybe you place yourself near the scene of the crime, even for a perfectly innocent reason. You've just become a key witness against yourself. Maybe you reveal a plausible motive. You mention you were angry at the person who was assaulted. You've just handed the prosecutor a motive on a silver platter. Second, human memory is flawed. Under stress, it's even worse. The detective will ask you to recount every detail of your day. What did you have for lunch? What time did you leave work? What color was the car parked next to you? Then an hour later, he'll ask you again. If you get one tiny detail wrong, you say it was a blue car. Then later you say it was a dark green car. He will pounce. So you're a liar. You lied to me about the car, what else are you lying about? You're lying about the whole thing, aren't you? They will use any inconsistency, no matter how trivial, to destroy your credibility and paint you as a deceptive, guilty person. And third, and most tragically, these techniques can lead to false confessions. Sounds insane. Why would anyone confess to a crime they didn't commit? But it happens. It happens all the time. After hours of isolation, exhaustion, and relentless psychological pressure, being told lies about mountains of evidence, being offered a way out through minimization, a person's will can break. They start to believe the false reality the detective has created. They become so desperate to make the interrogation end, they'll sign anything, say anything, just to get back to a cell and sleep. They convince themselves they can confess now and sort it all out later with a lawyer. But by then it's often too late. A confession, even a false one, is the most powerful piece of evidence the prosecution can ever have. So what do? How do you fight back against a system that is designed to make you fail? You don't play the game. You use the two most powerful sentences you have. When Detective Miller finishes his friendly intro and asks you to tell him your side of the story, you look at him calmly and you say, clearly and without ambiguity, I am going to remain silent. I want a lawyer. That's it. You don't say, I think I should get a lawyer. You don't say, should I talk to a lawyer? You don't ask a question. You make two clear declarative statements. The moment you say those words, a constitutional switch is flipped. Legally, all questioning must cease. Immediately. Now the detective won't like this. He might even act offended. He'll use one last set of tactics. He might say, whoa, a lawyer? Why do you need a lawyer if you have nothing to hide? Only guilty people lawyer up. This is a lie and it's a manipulation. Invoking your constitutional rights is not an admission of guilt. It is an act of profound intelligence. He might try to bargain with you. Look, if you ask for a lawyer, I have to charge you with the most serious crime possible and book you. But if you just talk to me, maybe we can work something out. Get this charge reduced. This is almost certainly a lie. The detective often has very little to do with the actual charges filed. That's up to the prosecutor's office. He is just trying to stop you from ending the interrogation. Your response to all of this must be the same. You become a broken record. Why do you need a lawyer? I want a lawyer. Just tell me this one thing and I'll leave you alone. I am going to remain silent. You're making a big mistake. I want a lawyer. You do not engage. You do not explain. You do not argue. You simply repeat the magic words. Eventually defeated, the detective will have no choice but to leave the room. The door will close and you will be alone again. The silence will rush back in. But this time it will feel different. In that overwhelming, terrifying process, you will have just taken back one small, but incredibly significant piece of control. You have shielded yourself. You have stopped yourself from becoming the prosecution's star witness. But the process is far from over. You've asked for a lawyer. How do you get one? You're still locked in a room, deep inside a police station. What happens next? Well, you have the right to a phone call. But who you call, what you say, and what you absolutely must not say on that call can be the difference between building a defense and digging your own grave. That single phone call is one of the most misunderstood and dangerous moments in the entire arrest process. Forget what you've seen in movies. The idea of a frantic, whispered call to a loved one, pouring your heart out while a benevolent officer looks the other way. That's pure fiction. The reality is a cold, calculated procedure, and that phone is not a lifeline. It's a microphone, and the audience is the prosecution. The first thing you must burn into your memory is this. With one critical exception, you have zero expectation of privacy when making a call from a police station. That friendly officer who says, "Go ahead, take your time," he's not being nice. He's giving you enough rope to hang yourself. Virtually every single outgoing call from a jail or police station is recorded. And they aren't just recorded for quality assurance. They are actively monitored by investigators looking for one thing: an admission, a slip of the tongue, a piece of the puzzle they can use to build their case against you. Every word you say can and will be twisted, analyzed, and presented to a jury. Think of it like this: you are willingly creating evidence. The prosecutor doesn't have to subpoena your phone records or get a warrant to listen in. You're handing them a pre-packaged confession on a silver platter. So who do you call? This isn't a strategic question. It's the only question that matters. You do not call your mom to tell her you're sorry. You do not call your best friend to ask them to bail you out. You do not call your significant other to cry and explain what happened. Your first and perhaps only call should be to a criminal defense lawyer. Why? Because this is the one critical exception I mentioned. This is the one safe conversation you are legally allowed to have. It's called attorney-client privilege. This is a sacred legal principle in the United States that protects all communication between you and your lawyer. It means that what you say to your attorney in confidence cannot be used as evidence against you. Even if the police record the call, and they might, that recording is inadmissible in court. It's legally worthless to the prosecution. Calling a lawyer immediately does three things. First, it stops you from creating incriminating evidence against yourself. Second, it puts a trained professional on your side who knows the system, knows the local prosecutors, and knows the judges. They can immediately start advising you on what to do and, more importantly, what not to do. Third, invoking your right to an attorney legally obligates the police to stop questioning you. The interrogation, the psychological games, the pressure. It all has to stop the moment you say, "I want my lawyer." Now let's be realistic. You might not have a lawyer's number memorized. In that case, you call the one person you trust most to find one for you. A spouse, a parent, a sibling. But the script for this call is incredibly important and brutally short. You must treat it as if the lead prosecutor is on the line with you, taking notes. Here is exactly what you say. "I have been arrested. I am at the name of the town or precinct police station. I am okay, but I cannot talk about anything that happened. I need you to find a criminal defense attorney for me right now. I will not speak to anyone until I have a lawyer. I love you. Goodbye." That's it. You do not apologize. Apologies sound like admissions of guilt. "I'm so sorry I messed this up," becomes the defendant express remorse for his actions in a police report. You do not explain the situation. "I was just in the wrong place at the wrong time," confirms you were at the scene of the crime. You do not try to shift blame. "It was all Mike's idea." Now makes you a key witness against Mike and potentially an accomplice. And under absolutely no circumstances do you ask someone to hide or destroy evidence. Asking a friend to go clear out my car or delete those text messages is a separate, serious felony called obstruction of justice. You could be innocent of the original crime but go to prison for trying to cover your tracks. Let me give you a real-world example of how this goes wrong. A young man is arrested for possession of illegal substances found in his apartment. He's scared. He calls his roommate. He says, "Dude, they're here. Did you get rid of the stuff in the garage like I asked?" In that one sentence, he not only admitted to knowing about other illegal items, but he also implicated his friend in a conspiracy. The police now have a recording they can use to pressure the roommate into testifying against him. He turned a difficult situation into an impossible one. Another case. A woman arrested after a bar fight. She calls her boyfriend, sobbing, "I didn't mean to hit her that hard. She just kept pushing me." The prosecution's case for assault was shaky. It was a chaotic scene with conflicting witness statements. But that recorded phone call? It became the star witness. Her own words, filled with emotion, painted a vivid picture of guilt for the jury that no lawyer could erase. After that phone call, whether you reached a lawyer or a loved one, you'll be escorted to the next stage, booking. This is the administrative process of officially entering you into the system. It's not an interrogation, but it's still a minefield if you're not careful. First, the mugshot. They'll have you stand against a wall and take your picture from the front and the side. This photo goes into a database for identification. Then comes fingerprinting. They'll either use the old-school ink and roll method or a digital scanner. These prints are run through state and federal databases, like AFIS, the Automated Fingerprint Identification System, to see if you have any prior arrests or outstanding warrants anywhere in the country. Next, they'll ask for your pedigree information. This is your name, date of birth, address, and other basic identifying details. You are generally required to provide this information. This is not a violation of your right to remain silent. Your identity is not self-incriminating. Refusing to identify yourself can often lead to an additional charge, like resisting or obstructing an officer. Then, they will inventory your personal property. They'll take your wallet, your phone, your keys, your belt, even your shoelaces. They will list every single item on a form, which you should be asked to sign. Pay close attention to this. Make sure everything is accounted for. This process serves two purposes. First, to keep your property safe while you're in custody. Second, and more critically, it's to ensure you don't have any weapons, contraband, or anything you could use to harm yourself or others. Every item they take is a potential piece of evidence. The contents of your wallet, the call log on your phone, It all might be examined later, pending a warrant. Finally, there may be a brief medical screening. They'll ask if you have any injuries, medical conditions like diabetes or epilepsy, or if you're on any medication. It's crucial to be honest here. If you need medical attention, this is the time to say so. Throughout this entire booking process, it is vital to understand the difference between a booking question and an interrogation question. What is your date of birth? Is a booking question. Who were you with on Friday night? Is an interrogation question. The officer at the booking desk might try to blur that line. He might ask casually, "So what's a guy like you doing in a mess like this?" Or "Crazy night, huh?" These are not friendly small talk. These are baited hooks. They are attempts to get you talking. Your response to every single question that isn't about your basic identity should be the same 5 magic words. I want to speak to my lawyer. Be polite, be calm, but be a broken record. They are legally required to stop asking questions about the case once you invoke that right. You've made your one phone call. You've been photographed, fingerprinted, and all your worldly possessions have been taken from you and sealed in a plastic bag. You are now officially booked. They lead you down a cold, sterile hallway, and the heavy door of a holding cell clangs shut behind you. You're alone with your thoughts in a concrete box. The minutes feel like hours. Then you hear footsteps, the rattle of keys. The door swings open. But it's not your lawyer. It's a detective. He's not in a uniform. He has a calm, reassuring look on his face. He pulls up a chair, sits down, leans forward, and says with a disarming smile, "Look, I think there's been a big misunderstanding. Why don't you and I just talk, and we can get this all sorted out? This is the moment. This is where your rights face their greatest test. The detective in front of you isn't here to help you. He is a master of psychological warfare, and his one and only mission is to get you to confess. How do you survive the interrogation room when every instinct is screaming at you to explain, to defend, to just talk your way out of it? The techniques they use are powerful, they are proven, and they are designed to break you. And the only way to beat them is to understand them first. One of the most widely used and psychologically devastating interrogation frameworks in the United States is known as the Reed technique. It's not a conversation. It's a 9-step psychological assault course designed with a single solitary goal: to make a suspect confess. It operates on the presumption of guilt. From the moment you walk into that room, the interrogator's job isn't to discover the truth. It's to secure a confession from the person they've already decided is guilty. You. Starts with the room itself. Small. Bare. No windows. No clock on the wall. This is deliberate. It's called conditioning. They are removing all external distractions, all sense of time, all connection to the outside world. Your entire reality shrinks to just you, the detective, and the 4 walls. You are isolated, powerless, and that's before they even say a word. Then the lead interrogator walks in. They're not your friend. They might act like it later, but they're not. They will often present a case file, maybe dropping it on the table with a thud. This is theater. Inside that file could be nothing but blank paper, but it's a prop. It represents the mountain of evidence they have against you. This is the first direct confrontation. They will look you in the eye and state with absolute, unwavering certainty that you committed the crime. We know you did it. We have 2 witnesses who saw your car. We found your DNA at the scene. It's over. The only thing we don't know is why. Now let's pause here for the single most important fact you need to understand about this entire process. A fact that shatters everything you've seen on TV. In the United States, law enforcement officers are legally permitted to lie to you during an interrogation. Let me repeat that so it sinks in. They can lie. They can lie about having witnesses who don't exist. They can lie about finding your fingerprints when they found nothing. They can lie and say your co-defendant in the other room has already confessed and implicated you. They can produce fake lab reports, fake polygraph results. It is all part of the game. And the purpose of this initial aggressive lie is to shock you into a state of despair. To make you believe that the fight is already lost. That no matter what you say, no one will believe you because the evidence is overwhelming. Your denials become pointless. Your alibi seems irrelevant. They have just created a fictional reality where you are already convicted, and your only hope is to cooperate within their narrative. Once they see that despair setting in, the tone shifts. This is where the real psychological manipulation begins. They begin to develop a theme. They don't try to convince you that you're a monster. Just the opposite. They offer you a way to see yourself as a good person who did a bad thing for an understandable reason. They provide you with moral excuses. They'll say things like, "Look, I've seen this 100 times. He provoked you, didn't he? He pushed you too far. Anybody would have snapped. You're not a bad guy. You just made a mistake in the heat of the moment. Or you were in a tough spot. The financial pressure was immense. You did it for your family, right?" That's not being a criminal, that's being a human being. This is called minimization. They are minimizing the moral and legal consequences of the crime, making it sound more like an understandable accident or a justifiable reaction than a felony. They are building a golden bridge for you to walk across, from your claims of innocence to a full confession. They are giving you a story you can tell yourself, a story that lets you confess while still preserving some shred of your self-respect. As they build this theme, they will relentlessly shut down any attempts you make to deny your guilt. If you say, "I didn't do it," they'll respond with, "Look, we are past that. That ship has sailed. Talking about that is not going to help you. We need to talk about why this happened." That's what the judge and jury will want to understand. They deflect, they interrupt, they accuse you of lying. Over and over. For hours. Every denial is met with a psychological wall. The message is clear. The only way out of this room, the only path forward is through admission. Your brain, under incredible stress and exhaustion, starts to look for a way out. The theme they've offered you, the story of the accident or the provocation, starts to sound less like a lie and more like a lifeline. This is where the infamous good cop/bad cop routine comes from, though it's often more subtle. One detective might be aggressive and intimidating. That's maximization. They'll talk about the maximum prison sentence, life without parole, how you'll never see your family again. They paint the bleakest possible picture. Then a second detective comes in. He's kind, offers you a soda, speaks in a soft voice. He's the minimizer. "My partner, he's a hard ass. But I don't see you that way. I think you're a good person who got caught in a bad situation. Just tell me what happened and I can help you. I can talk to the DA. Tell them you cooperated." It's a psychological pincer movement. One side is crushing you with fear. The other is pulling you in with false hope. The stress becomes unbearable. This is how innocent people confess. They become so disoriented, so exhausted, so convinced by the fake evidence, and so desperate to escape the psychological torture of the interrogation, that they start to believe that confessing is their only option. They think, "If I just tell them what they want to hear, I can get out of this room, get a lawyer, and sort it all out later." But it never gets sorted out later, because the confession is the end game. After hours of this relentless pressure, when you are at your absolute breaking point, they deploy the final trap. It's called the alternative question. They will lean in, look at you with what seems like sympathy, and ask a question that presents two choices. But both choices are an admission of guilt. It won't be, "Did you do it?" It will be, "Did you plan this out for weeks? Or did it just happen on the spur of the moment?" Or, "Did you mean to hurt him that badly? Or was it just an accident that went too far?" Think about those questions. If you say it was spur of the moment, you've just admitted to doing it. If you say it was an accident, you've just admitted to being there and being responsible. There is no third option. There is no, "I didn't do it." They have framed the entire universe of possibilities down to two scenarios, and both of them convict you. To a brain that has been under siege for hours, grabbing onto the lesser of the two evils feels like a victory, feels like relief. You confess to the minimized version of the crime they handed to you on a silver platter, and with that it's over. They have what they want. The moment those words leave your mouth, your life is irrevocably changed. The friendly detective who promised to help you will stand up. His demeanor will turn cold, and he will leave the room to write up the report that will be used to take away your freedom. That confession, born from lies, fear, and psychological manipulation, has now become the single most powerful piece of evidence the prosecution has against you. It is a cannonball aimed directly at your future, and you handed it to them yourself. So what happens next? What happens when that confession, whether true or false, enters the legal system? That confession now becomes the cornerstone of the official police report. It's typed up, signed, and placed in a file that will follow you like a shadow for the rest of this journey. The friendly detective who just ruined your life pats you on the back, the warmth of his hand a chilling contrast to the cold steel of the cuffs now being reapplied to your wrists. The interrogation is over. The administrative processing of your life has just begun. You are led from the small windowless room into a brightly lit, sterile area that smells of disinfectant and bureaucracy. This is booking. It's a disassembly line for human identity. First, your personal property is taken. Your wallet, your keys, your phone, the small talismans that connect you to your world, are removed, cataloged, and sealed in a plastic bag. You are, quite literally, being disconnected from your life. Then comes the search. It is thorough, invasive, and designed to strip away the last vestiges of your privacy. Every pocket, every seam, every inch of your body is examined. You are no longer a person. You are a potential container for contraband, a security risk to be managed. Next, you're placed in front of a height chart. A digital camera flashes, capturing the single worst moment of your life for posterity. This is your mugshot. It's a stark, emotionless photograph that will become the public face of your alleged crime. It will be seen by your family, your friends, your employer, and millions of strangers on the internet. It doesn't capture who you are. It captures who the state says you are at this exact moment. A criminal defendant. Then your hands are taken one by one. Each finger is rolled in cold, black ink and pressed firmly onto a card. These are your fingerprints, a unique biological signature that is now being uploaded into a vast, interconnected network of databases. AFIS, the Automated Fingerprint Identification System. From this moment on, your prints will be in the system, forever linking you to this arrest regardless of the outcome. Finally, after the pictures and the prints, after you have been thoroughly documented and depersonalized, you are granted a right that is surprisingly not in the Constitution, but is enshrined in most state laws, the right to a phone call. You're handed a receiver, slick with the sweat and desperation of countless others before you, and you have a choice to make. Who do you call? Your first instinct is to call a loved one. Your spouse, your parent, your best friend. You want to hear a familiar voice, to cry, to explain, to vent your fear and frustration. This is a trap. Above the phone, or on the wall nearby, is a sign you must not ignore. It says, "All calls are recorded and may be monitored." Let me be clear. This is not a suggestion. It is a guarantee. Detectives and prosecutors listen to these calls as a matter of routine. They are fishing for information. They are listening for you to say something, anything that can be used against you. When you tell your mom, "I really messed up," the prosecutor hears a confession. When you tell your friend, they know everything. The prosecutor hears a confirmation of guilt. You think you're having a private, desperate conversation, but you are creating Exhibit B for the prosecution. The only safe call is to a lawyer. A conversation with your attorney is privileged and cannot be used against you. Any other call is a potential landmine. After the call, a heavy steel door clangs shut behind you. You are now in a holding cell, often called the tank. It is a concrete and steel box, often filled with a rotating cast of characters from every walk of life, all united by their current predicament. The air is thick with the smell of unwashed bodies, stale food, and anxiety. There are no clocks, and the fluorescent lights are always on, creating a timeless, disorienting limbo. Hours stretch into what feel like days. The only sound is the echoing coughs of other detainees and the distant, metallic clang of doors opening and closing. Here you wait. But what are you waiting for? You're waiting for a decision to be made by someone you've never met, in an office you'll never see. While you sit in that cell, your file, now containing the police report and your signed confession, lands on the desk of a prosecutor. In the United States, the police do not charge you with a crime. They arrest you. It is the prosecutor, an agent of the state, who holds the sole power to formally file charges. The prosecutor reads the report. They see the alleged crime, the evidence collected, and then they see it, your confession. Their job, which is to prove a case beyond a reasonable doubt, just became exponentially easier. Your own words have built the bridge from suspicion to near certainty in their mind. The confession doesn't just influence if you get charged, it influences what you get charged with. An ambiguous case might have resulted in a lesser charge. But with a confession, the prosecutor feels confident aiming for the most serious offense possible. They sign the charging document, and with that stroke of a pen, you are no longer just an arrestee. You are now a defendant in a criminal case. The state has formally declared war on your freedom. Within 24 to 72 hours of your arrest, you will be taken from the holding cell and brought to a courtroom for your first appearance, known as the arraignment. Shackled at the wrists and ankles, you'll be led into a courtroom filled with other defendants, all looking as lost and terrified as you feel. When your name is called, you'll stand before a judge, a figure in a black robe who holds your immediate future in their hands. The judge will read the formal charges against you. Hearing them spoken aloud, in the solemnity of a courtroom, makes them terrifyingly real. The judge will then advise you of your constitutional rights, including the right to an attorney. If you cannot afford one, the court will appoint one for you. A public defender will be assigned to your case, often meeting you for the first time just moments before you stand in front of the judge. Then 2 critical decisions are made that will alter the entire trajectory of your case: your plea and your bail. At this stage, your attorney will almost always enter a plea of not guilty on your behalf, even if you've confessed. This is a procedural step that keeps your legal options open. Then comes the main event: bail. Bail is not a punishment. It is not a fine. It is a financial guarantee that you will return for your future court dates. The judge has to decide whether to release you on your own recognizance, your simple promise to return, or to set a monetary amount. To make this decision, the judge considers the severity of the charge, your past criminal record, your ties to the community, and whether you are a flight risk or a danger to the public. And this is where your confession comes back to haunt you in the most devastating way. The prosecutor will stand up and tell the judge, "Your Honor, the state has a very strong case. The defendant has already confessed to the crime." In the judge's mind, the risk of you fleeing just skyrocketed. If you've already confessed, what incentive do you have to stick around and face a near-certain conviction? The likelihood of guilt seems high, so the perceived danger you pose to the community also increases. The judge, hearing this, is far more likely to set a high bail amount, an amount you and your family likely cannot afford. $10,000, $50,000, $100,000 or more. To get out, you'd have to pay a bail bondsman a non-refundable fee, typically 10% of that total. That's money you will never get back. And if you can't pay, if that number is simply too high, you are sent back to jail. Not prison, but a local or county jail, where you will be held in pretrial detention. You will remain locked in a cage until your case is resolved. This could be weeks, months, or in some overloaded court systems, even years. This is the hidden crisis of the American justice system. You are legally innocent until proven guilty, yet you are incarcerated. While in jail, you can lose everything. Your job because you can't show up for work. Your apartment because you can't pay the rent. Even custody of your children. The pressure becomes immense. Every day spent in a cell grinds you down, making you more and more desperate to get out. You're either walking out the front door of the courthouse dazed and trying to figure out how to pay a bondsman back while a criminal trial looms over your head, or you're being led through a back door back to a cell stripped of your freedom before you've had a chance to fight. And it is from that position of either relative freedom or profound weakness that the next most crucial phase of this war begins: the plea bargain. The plea bargain. It's a term we hear all the time on TV, but the reality is far more brutal and consequential than any drama can capture. It's not a sideshow to the main event. In the American justice system, the plea bargain is the main event. Forget what you see in movies about dramatic courtroom showdowns. Over 97% of all federal criminal cases, and around 95% of state cases, end in a plea bargain. They never see a jury. The system isn't designed for trials. It's designed for deals. It is an assembly line, and its primary function is to secure convictions as efficiently as possible. This process begins almost immediately. Your defense attorney, whether they're a high-priced private lawyer or an overworked public defender, will receive an offer from the prosecutor. And this is where the terrifying calculus of American justice comes into focus. The prosecutor doesn't just charge you with the one crime they think you committed. That's not how the game is played. They engage in a practice called charge stacking. Let's imagine a simple scenario: a bar fight. You push someone, they fell, maybe they got a cut. In a common-sense world, you might be charged with simple assault. But a prosecutor with leverage on their mind can paint a much darker picture. They can charge you with felony aggravated assault, battery, reckless endangerment, and disorderly conduct. Suddenly, you're not facing a year in jail. You're facing a potential decade or more in prison, spread across 4 different charges. They have thrown the entire book at you, even the parts that barely stick. Why? To create fear. To create leverage. To make the plea offer seem like a lifeboat in the middle of a hurricane they themselves have created. The prosecutor then has your lawyer deliver the offer. Sounds like a lifeline. "Look," the prosecutor says, "we have all these serious charges. This could ruin your life. But if your client pleads guilty right now to just the single charge of simple assault, we'll drop the other 3. They'll get a guaranteed sentence of 6 months probation and a fine. No jail time. Take it or leave it." And this is where you, the defendant, are placed in an impossible position. Your lawyer is now forced to become less of a warrior and more of a risk analyst. They'll sit down with you in a small sterile room and lay out the grim mathematics. They'll say, "Listen, I believe you're innocent. I believe we could win at trial. But we have to be realistic. Juries are unpredictable. All it takes is one witness misremembering, one piece of evidence being misinterpreted. If we go to trial on all 4 of these charges and we lose, the judge could sentence you consecutively. You could be looking at 10 years in prison." 10 years. They continue. The prosecutor is offering you a guarantee. You walk out of here with probation. No prison. You get to go home to your family, go back to your job. But you will have a criminal record. You will be a convicted criminal for the rest of your life. If we fight, there's a chance, maybe a good chance, we walk away with nothing. You're a free person with a clean slate. But if we lose, you lose everything. This is what's known as the trial penalty. It is the dark secret of the justice system. The system actively and harshly punishes individuals for exercising their Sixth Amendment constitutional right to a trial by jury. The difference between the sentence in a plea offer and the potential sentence after a trial conviction is so vast, so terrifyingly disproportionate, that it becomes coercive. It's not a free choice. It's a decision made with a gun to your head. What would you do? Would you risk 10 years of your life, 10 years away from your children, your spouse, your entire world for the principle of your innocence? Or would you take the guaranteed deal that lets you go home, even if it means admitting to something you didn't do? Even if it means carrying the stain of a conviction forever? This is the torment that millions of Americans face. The choice isn't between guilty and not guilty. It's between a definite, manageable bad outcome and a possible life-destroying catastrophic outcome. You're forced to gamble with years of your life as the chips. And for the truly innocent, this is a special kind of hell. Imagine you did nothing wrong. You are factually innocent. The prosecutor's case is weak, but not non-existent. They have an eyewitness who is mistaken but confident. Your lawyer tells you that you have an 80% chance of being acquitted at trial. An 80% chance sounds pretty good, right? But what about the other 20%? Is your freedom, your life, worth a 1 in 5 risk of being locked in a cage for a decade? This immense pressure has created one of the most bizarre and troubling mechanisms in the entire legal system: the Alford plea. Named after a 1970 Supreme Court case, an Alford plea is a paradoxical arrangement where you, the defendant, can plead guilty to a crime while simultaneously maintaining your innocence. You are literally telling the court, "I did not do this, but I believe the prosecutor has enough evidence to potentially convince a jury that I did, and I am taking this plea deal to avoid the risk of a harsher sentence at trial." Think about that. The system is so coercive that it has a formal, recognized procedure for innocent people to plead guilty. It is a tacit admission by the courts themselves that the trial penalty is so powerful, so effective, that it can compel an innocent person to confess to a crime they never committed just to make the nightmare stop. It is the ultimate perversion of justice, where self-preservation forces you to participate in your own wrongful conviction. The plea bargain is the prosecutor's kingdom. They decide what to charge, what offers to make, and when to make them. A defense attorney can negotiate, they can argue, they can point out weaknesses in the state's case to try and get a better deal. But at the end of the day, the power is almost entirely one-sided. The prosecutor is both the dealer and the house, and the deck is stacked. So you sit there, in that little room with your lawyer, with your life hanging in the balance. The offer is on the table. It has an expiration date. Prosecutors often use what they call exploding offers, deals that are only good for a very limited time to increase the pressure, to prevent you from having too much time to think or for your lawyer to investigate further. You have to decide. Now, do you roll the dice and fight for your name in a trial that could cost you everything? Or do you swallow your pride, surrender your innocence, and take the deal that lets you walk away, forever branded a criminal? Every instinct for survival screams at you to take the deal. End the uncertainty. Limit the damage. Go home. But every fiber of your being that believes in justice, in truth, in your own innocence screams to fight. This decision, made under duress and driven by fear, will dictate the entire future of your case. It is the most important door you will walk through, and once you make that choice, there is no going back. Whether you accept the deal and prepare for sentencing, or reject it and prepare for war, the system is about to show you what happens next. If you've accepted the plea deal, your path forward is grimly straightforward. You are now awaiting sentencing. This isn't a quick formality. The court will order something called a pre-sentence investigation report, or a PSI. Think of it as a complete autopsy of your life, conducted while you're still living. A probation officer will be assigned to dig into every corner of your existence. They'll talk to your family, your friends, your past employers. They'll scrutinize your school records, your finances, your medical history, and your prior criminal record if you have one. They want to know everything. Your childhood, your struggles with addiction, your greatest achievements, and your deepest shames. Every piece of information, good or bad, is compiled into a comprehensive document for the judge. This report will recommend a sentencing range based on established guidelines, but it also paints a portrait of you as a human being. Your attorney will have a chance to object to inaccuracies and submit letters of support from your community, trying to add color and context to the black and white facts of your crime. But make no mistake, at the sentencing hearing, you will stand before a judge who likely knows more about you than some of your closest relatives. They will listen to the prosecutor, they will listen to your attorney's plea for leniency, and they may even hear from the victims of your crime. And then, with the weight of that report and the power of the state, the judge will decide your fate. A number of years, a list of conditions, a debt to be paid. Your choice was to surrender, and this is the price. But what if you didn't surrender? What if you looked at the deal on the table, with all its supposed certainty, and you said no? What if you pushed all your chips to the center of the table and chose to fight? Then you have prepared for war. You are going to trial. This is the moment the entire American justice system is built around. It's the scene from every movie, the climax of every legal drama. But when it's your life on the line, it feels nothing like fiction. It begins with a process that sounds deceptively simple: jury selection. Or as the courts call it, voir dire, a French term meaning to speak the truth. 12 people, plus a few alternates, will be chosen from a pool of ordinary citizens to sit in judgment of you. But how they are chosen is a masterful psychological game of chess. The judge, the prosecutor, and your defense attorney will question these potential jurors, and they aren't looking for the 12 most impartial Spock-like logicians in the room. That's a myth. The prosecutor is looking for 12 people who are predisposed to trust authority, to believe law enforcement, and to see the world in terms of right and wrong. Your defense attorney is looking for 12 people who are skeptical of the system, who are open to nuance, and who might have a reason to doubt the story the state is about to tell. Each side gets a certain number of peremptory challenges, which means they can strike a juror for almost any reason at all, without having to explain why. They don't like the way someone looked at their client? Gone. They have a gut feeling about someone's bumper sticker? Gone. It is a brutal process of elimination, a high-stakes effort to sculpt the audience that will ultimately decide your future. Once those 12 people are seated in the jury box, the war begins with opening statements. This is the movie trailer for the case. The prosecutor goes first. They will stand before the jury, make eye contact, and tell a story. It will be a clear, compelling narrative of what they believe you did. They will introduce you as the villain, the victims as the heroes, and the evidence as the undeniable proof. They will lay out a roadmap for the jury, promising to prove beyond a reasonable doubt that you are guilty. That phrase is the bedrock of your defense. Beyond a reasonable doubt. It is the highest burden of proof in the American legal system. It doesn't mean beyond any doubt, or beyond a shadow of a doubt. It means that the jurors must be so convinced that there is no other logical explanation, based on the facts presented, for what happened. It is a formidable wall for the prosecution to climb. Then your attorney stands. Their job is not necessarily to prove you are innocent. Their primary job is to show that the prosecution cannot climb that wall. They will present their own trailer. They will punch holes in the prosecutor's story before it's even been told. They will introduce the theme of doubt. They will suggest alternative theories, question the motives of witnesses, and highlight the gaps in the police investigation. They are planting seeds of uncertainty, reminding the jury that the burden of proof rests entirely on the state. You are presumed innocent, and that presumption is a shield. With the stage set, the prosecution begins its case in chief. This is the assault. One by one, they will call their witnesses to the stand. Police officers will detail your arrest. Forensic experts will talk about fingerprints and DNA. Eyewitnesses will point you out in the courtroom. The prosecutor will guide them through their testimony with direct examination, building their narrative brick by brick. But after each witness tells their story for the prosecution, your defense attorney gets to cross-examine them. This is where the battle is truly joined. Cross-examination is an art form designed to dismantle, discredit, and create doubt. Your lawyer will use pointed, leading questions to control the witness. They will expose inconsistencies in their story, challenge their memory, question their biases, and reveal any motives they might have to lie. Every yes or no answer is a potential crack in the prosecution's wall. Once the prosecution has presented all its evidence and called all its witnesses, they will stand and say the words, "The government rests." A profound silence hangs in the air. The assault is over. Now the defense must decide how to respond. This leads to the single most consequential decision of the entire trial: whether or not you will testify in your own defense. The Fifth Amendment to the Constitution gives you the absolute right to remain silent. The prosecution cannot force you to testify, and the jury is explicitly instructed that they cannot hold your silence against you. But jurors are human. In that little room away from the judge's instructions, a question will linger. If he was innocent, why wouldn't he just get up there and say so? Testifying means you get to tell your story in your own words. You can look the jury in the eye and declare your innocence. You can explain away the state's evidence. You can be human, relatable, a person instead of a defendant. But it also means the prosecutor gets to cross-examine you. They will be relentless. They will twist your words, dredge up every mistake you've ever made, and do everything in their power to make you look like a liar to the jury. It is a monumental risk. Whether you testify or not, your attorney may call other witnesses, alibi witnesses, character witnesses, or dueling experts to counter the state's narrative. Or they may call no witnesses at all, choosing to argue that the prosecution's case was so weak that it simply doesn't require a response. They can rest their case entirely on the belief that the state has failed to meet its burden of proof. Once the defense rests, there is only one thing left: closing arguments. This is the grand finale. The prosecutor goes first, weaving every piece of testimony and evidence into one final powerful story of guilt. They will appeal to the jury's sense of logic, their emotions, and their duty to the community. They will point at you and tell the jury that you are the person responsible. Then your defense attorney delivers their closing. It is a final passionate plea for your freedom. They will be the voice of reasonable doubt, reminding the jury of every inconsistency, every unanswered question, every crack in the state's case. They will hold up the shield of presumed innocence one last time, and implore the jury not to convict a person when doubt remains. Finally, the judge reads a long list of complex legal instructions to the jury, explaining the laws they must apply. An alternate juror is dismissed, and the remaining 12 rise. They file out of the courtroom, a bailiff leads them to a private room, and the door is closed. The talking is over. The evidence has been presented. The arguments have been made. And now, in a small, quiet room, 12 strangers begin to decide your life. Their decision will be one of two words: guilty or not guilty. And you can do nothing but wait. The waiting is a unique form of torture. The world, which had been moving at a frantic, terrifying pace, suddenly grinds to a halt. In the sterile quiet of the courtroom or a holding cell, every tick of the clock is a hammer blow against your sanity. Hours can feel like days. A day can feel like a lifetime. Because in that small, sealed room, the jury is deconstructing your life, piece by piece. They begin by electing a foreperson, a leader to guide their discussion. Then they ask for the evidence. The alleged weapon, the bag of drugs, the grainy surveillance video, the stack of financial records. It's all wheeled into their room on a cart. They can hold it, examine it, pass it around. They can ask to have testimony read back to them, to hear a witness's words one more time, stripped of the courtroom drama. They are armed with the evidence, the exhibits, and one other critical tool: the judge's instructions. These instructions are the rulebook. Before they began deliberating, the judge read them a long, complex set of legal definitions. What constitutes possession? What is the legal definition of intent? And most importantly, what does it mean to be convinced beyond a reasonable doubt? This is the bedrock of American justice, and it's one of the most misunderstood concepts. It does not mean beyond all doubt. It doesn't mean a shadow of a doubt. The system acknowledges that absolute certainty is almost impossible. A reasonable doubt is a real doubt, based upon reason and common sense after careful and impartial consideration of all the evidence. It's the kind of doubt that would make a reasonable person hesitate to act in a matter of the highest importance in their own life. Would you bet your life savings on this? Would you stake your child's future on this conclusion? If you would hesitate, that's a reasonable doubt. Inside that room, 12 different life experiences collide. A retired accountant might be focused on the numbers. A young teacher might be weighing the credibility of a witness. A construction worker might see a flaw in the physical evidence that everyone else missed. They argue. They debate. They try to persuade each other. Voices are raised. Tempers can flare. People dig in their heels. Others begin to question their own initial judgments. It is a microcosm of democracy itself, messy, emotional, and intensely human. Their goal is to reach a unanimous decision. All 12 must agree. But what if they can't? What if 11 people are convinced of guilt, but one person holds firm, believing in a reasonable doubt? Or the other way around. If, after hours or even days of deliberation, they are hopelessly deadlocked, the foreperson will send a note to the judge. The judge might read them what's called an Allen charge or dynamite charge, an instruction urging them to continue deliberating, to listen to each other, and to try to break the impasse. But if they still can't agree, the judge has no choice but to declare a mistrial. The jury is hung. For the defendant, a hung jury is a strange, agonizing limbo. You are not guilty, but you are not free. The charges are not dropped. The sword of Damocles still hangs over your head, and the prosecutor now has a choice. They can drop the case, they can offer a new, more aggressive plea deal, or they can decide to do the whole thing all over again. A new trial with a new jury. For the defendant, who has already exhausted their life savings and emotional reserves, the prospect of going through that hell a second time is a devastating blow. But in most cases, a decision is reached. A note is passed from the jury room to the bailiff. The bailiff gives it to the judge. The judge's face remains a perfect, unreadable mask. A call is made. The lawyers are summoned. The defendant is brought back into the courtroom. The air becomes thick, heavy, electric. You can hear your own heartbeat in your ears. The jury files back in and everyone in the room scrutinizes their faces, looking for a sign, a tell, any clue to what's coming. But they've been instructed not to make eye contact with anyone. They look at the floor, the ceiling, the wall, anywhere but at you. The court clerk asks the foreperson, "Have you reached a verdict?" The foreperson stands. "Yes, we have." The defendant is ordered to rise and face the jury. The verdict form makes its final journey, from the foreperson to the bailiff, from the bailiff to the judge. The judge reads it, and the silence in the room becomes absolute. The judge hands the form back, usually to the clerk, to be read aloud. Time seems to stretch and distort. The clerk unfolds the paper, and then the words come. On the charge of "we the jury find the defendant not guilty." The sound is a sudden violent exhale from everyone in the room who was on your side. It's a tidal wave of relief so powerful it can buckle your knees. The world rushes back in, colors seem brighter, sounds sharper. Your lawyer claps you on the shoulder. Your family may be sobbing with joy in the gallery. You are acquitted. And in the United States, this verdict is final. The principle of double jeopardy means the government gets one shot. They cannot appeal. They cannot recharge you. They cannot try you for this crime ever again. It is over. You'll be processed out, given back the property they took from you when you were arrested. You walk out of the courthouse a free person. But freedom doesn't mean you're whole. You may be financially destroyed. Your reputation might be in tatters. Your name will forever be linked to the accusation online. The trauma of the arrest, the trial, the waiting, that doesn't just vanish. You won the case, but the process itself has inflicted a wound that may never fully heal. But there is another possibility. The clerk unfolds the paper, clears their throat and says, "On the charge of we the jury find the defendant guilty." That one word lands like a physical blow. It sucks the air from your lungs and the strength from your limbs. The world doesn't rush in. It collapses. The sounds of the courtroom, the gasps from your family, the quiet shuffling of the prosecutor's papers, become distant and muffled, as if you're underwater. In many cases, the judge will immediately say, "Remand the defendant into custody." The bailiffs, who had been standing impassively just moments before, move in. Your lawyer might put a hand on your arm, but they can't stop it. You are cuffed. You are led away through a side door out of the courtroom and back into the system. The last thing you might see is the face of your loved one, crumpled in despair. This verdict is not the end. It is the beginning of the next phase. You haven't been sentenced yet. That comes later, at a separate hearing, sometimes weeks or even months down the road. In the time between the verdict and the sentencing, a new process begins. A probation officer is assigned to your case to create something called a pre-sentence investigation report. This report is a deep dive into your entire existence. They will investigate your criminal history, your family background, your education, your employment history, your finances, your physical and mental health. They will talk to the prosecutor. They will talk to your defense attorney. They will create a comprehensive document for the judge that recommends a punishment. While your lawyer prepares to argue for leniency, you wait in a cell, replaying every moment of the trial, every decision you ever made. The jury has spoken. Your guilt, in the eyes of the law, is now a fact. The only question left is the price you are going to pay. And that price will be decided by a single person, the judge. Your fate is, once again, completely in someone else's hands.